Welcome to our criminal cases video. The purpose of this video is to outline for you what a criminal case is all about generally. Because if you're coming to this video, obviously there's something that's happened in your life or a loved one's life that you're interested. I want to stress this. This is a general overview. This is not everything there is to know about a criminal case. First of all, if you cannot afford, because you're unemployed, you're broke, you just plain flat out economically don't have the money, you can obtain a public defender appointed by the court that will cost you no money. Public defenders get a bad rap. Public defenders, I have found, do an excellent job. I'll go ahead and mention one by name. John Delaney, who is a public defender in Northern Kentucky, is as fine a lawyer as you're ever going to want to find. Guess what? If you don't have the money, just use a public defender. Bail and bond. As soon as you are charged and you're arrested, the court will set a bail and bond. Judges even do this over the weekend. They work with pretrial services. What determines your bail and bond? Have you ever skipped town before? Have you ever not showed up to court before? How extensive of a record do you have? How serious of a crime it is? And there's various forms of bond. Property bond, cash bond, 10% bond, and also an OR bond. If you're arrested for a DUI or disorderly conduct, chances are there's going to be no bond. If you're arrested for a violent crime, rape, murder, you're going to have a high bond. Recently, over in Hamilton County, for example, there was a bond, I think, on the Marcus Feisel case. I think Judge Dingelacker set that for like $10 million or something. It was an extraordinary bond to make a point. The arrest. Something that you need to know about the arrest. You can be arrested on the scene. You can be arrested based upon a warrant where they come and charge you, and sometimes they just file a criminal complaint. One of the things that I have to stress, and I don't know if it's on here, I actually prepared this PowerPoint, but I forget the outline. They do not have to read you your rights if you're arrested. Everybody thinks, they didn't read me my rights, Bulldog. They don't have to read you your rights. Only if there is a custodial interrogation. That's not at the scene. They're allowed to make inquiry there. What we're talking about is if they take you back to the jail, put you in a room, and they start interrogating you, then they have to read you your quote-unquote Miranda rights. The police. You're probably going to get arrested by a police officer normally, or a federal marshal, or a detective. I can't stress this enough to you. If you're going to be arrested by the police, the best thing you can do for your case is to cooperate. Be polite and be courteous. Let me tell you something. I sue police officers for misconduct. But I find in my own life, I've never been arrested. You know how many times I've been pulled over? I have a lead foot. If you are polite to the police officer, chances are you're more apt to get a break. And if you're arrested and down later in court your defense attorney wants to negotiate a deal with the prosecutor and the police officer is going to have his say, they're going to remember if you were an ass or you were nice. Now, I want to stress this to you. That's hard to do sometimes. If you feel like you're being wrongfully arrested, it's going to be hard to control your temper. I know how you feel. Try to. It's going to help your case. If you're being wrongfully arrested, guess what? We'll deal with that at a later date. Probable cause. They have to have probable cause to arrest you. They also have to have probable cause to continue the prosecution of your case. One thing I need to tell you about probable cause, nobody really knows what the hell that means. I mean, it's probable cause. And you know what? They can find probable cause pretty easy. I'll guarantee you that some police officer could find probable cause to arrest me probably for being in this courtroom with permission for trespassing. I don't know. But trust me, probable cause, it's hard to define what it is. It really is. Preliminary hearing. If you have been charged with a serious crime, and I want to stress, that's what I like. I mean, I represent people who have committed murder, rape, things like that. False rape. I don't like representing people who are guilty of rape. Bottom line is a preliminary hearing is where the prosecutor and the judge and you with your lawyer will determine whether or not they have probable cause to send it to the grand jury. It's called a preliminary hearing. The grand jury has the authority and the power to what's called indict you. This isn't the jury that decides whether you're guilty or innocent. Their only decision is to decide what charges are going to be pursued against you. And let me tell you something about the grand jury. Usually, the only people that are present in the grand jury room are the grand jury, the prosecutor, and the police officer. However, if you know that you are the subject of a grand jury investigation, you can ask the prosecutor, and I've never known it not to be granted, that you can testify to the grand jury and tell your side of the story. This past year, we headed off 2 cases of serious significance by my client testifying at the preliminary hearing or the grand jury. They were never charged. Recently, here in Boone County, where I am right now, I'm representing somebody who's accused of attempted murder, falsely. They took the case directly to the grand jury, what's called an information, and we didn't get a chance for my client to testify at the preliminary hearing or the grand jury. Here's the Bulldog's advice. If you are innocent, cooperate with law enforcement. Go to the preliminary hearing and testify. Go to the grand jury and testify. And, as you know, tell the world through the media that you're innocent. You gain nothing by keeping your mouth shut if you are innocent. Because you know what everybody thinks when you keep your mouth shut? That you're guilty. The indictment. That's what the grand jury delivers, and you're off and running in the criminal process. The arraignment, you all know what an arraignment is. It's where you plead not guilty, or what we call no contest. No contest means, it's called an Alford plea. It's based upon a case in North Carolina. What that means is that you're not admitting any guilt, but you're saying there's enough evidence to convict you if it were to go forward. Guilty, not guilty, and Alford plea. And by the way, the reason why even guilty people plead not guilty at the arraignment is because you have to have time to work a deal with the prosecutor, and that never happens at the arraignment. Status conferences. After the arraignment, the court will set status conferences to allow the parties to exchange discovery and documents. Very important to know, there's no secrets in this process. The prosecutor has to give you their case, their evidence, their witnesses. And that happens through these discovery. And there's status conferences. A big case is going to have a lot of status conferences. Discovery. There's standard discovery that exchange. You're going to get the police officer's notes, the police report. If it's a DUI, you're going to get the videotape. You're going to get the name of the witnesses. If there's a full-fledged investigation, they got to give it to you. You know why? So you can confront your accusers. You have to know what their case is all about. Pretrial. Pretrial is usually where if you're going to make a deal, that's where it's going to happen, at your pretrial. This is the last step before you have a full-blown trial. And as everybody knows from watching this on TV, a trial in a criminal matter, very important, some basics. You are presumed innocent until they prove you guilty beyond a reasonable doubt. But let me tell you something. They expect you and want you to testify. In this day and age, if you're innocent, Ryan Widmer, 3 chances, claimed he was innocent, never testified. My client, my famous teacher client, Nicole Howe, claimed she was innocent. Prior lawyer wanted her to plead guilty to a felony. Testified, not guilty. If you are innocent, you need to testify. Also, beyond a reasonable doubt. Lawyers aren't allowed to tell a jury what that is. Common sense, beyond all reasonable doubt. Another significant thing, in a criminal case, the jury has to convict you 100%. It's not the majority, 100%. One of the funnest cases I ever had was a DUI trial, which broke a record in Kentucky. It was tried twice for 2 full days, and I finally won. The first trial was a hung jury. They thought it had to be just majority. It was 4-2. I polled the jury. That's where you ask the jury what happened. And I found out that 2 of the jurors said not guilty. They thought it was majority. It has to be unanimous. Okay? Very important to know. That's why when you try a case, it's a victory if you just convince one. Why? It's a hung jury. They have to either try the case or maybe get a better deal. Guilty? You all know what that means. Not guilty? It's over. If you're found not guilty, that's when what we call double jeopardy attaches. If you're found not guilty, they can never try you for that again, even if you did it. and admit you did it. Now, you can't commit perjury. There's been people that testified, got off, then admitted it, then they nailed them for perjury. No contest, I already explained that. Sentencing. Sentencing is a complex situation. It depends on the case. Juries make recommendation, the judge does the sentencing. And despite the recommendation from the jury, the judge has broad powers to follow that sentencing or give you what's called probation. He can probate some or all of it. Also, what we call conditionally discharged. You've probably heard this if you've ever been in a courtroom. I hereby sentence you 60 days in jail, and everybody goes, conditionally discharged, that if you never commit another crime in the next 2 years, it goes away. Now, if you commit a crime or you violate the terms of that conditional release, diversion, or probation, then you're subject to possibly serving out your sentence. Public perception again. In my opinion, the public perception is if you are charged with a crime, you must be guilty. Why would the police and prosecutor pursue somebody if they're not guilty? And let me let you in on a secret. Chances are you are guilty. 95% of the people that are charged with crimes are guilty. They're guilty of what they're charged with, or a lesser crime, or they're guilty of something. However, that 5 to 10% people that get charged wrongfully, you got to stand up for yourself. But that is what you are up against when you're charged with a crime. Your friends, your neighbors, everybody thinks you're guilty. But let me just say this too. There but the grace of God goes I. What do I mean by that? Is that it's not just whether you're guilty or not, it's what is the just sentence and punishment for that. I marvel in the tri-state area in Kentucky and Ohio and around the country how the judges on the front line of this have an unbelievable sense of fairness and justice for individuals. One of my favorite is when I heard Judge Schmedeke look at an elderly man that was accused of a crime. When he canceled a check, he stopped payment on the check and was accused of theft by deception. He says, I'm not going to make a criminal out of your client today, Mr. Deters. And it was the right decision. It was a beautiful decision. They, day after day, see it all. They see the bad ones. They see the good ones. Good people sometimes do bad things. They don't deserve the book thrown at them. So there you have it, the public perception. Insanity plea, very complicated. The bottom line is, it used to be the McNaughton rule, right or wrong. Do you know the difference between right or wrong? It's much more complex. Bottom line is, leave this to the lawyers. Guilty versus not guilty, I've already explained all that. Polygraph. Let me tell you something else. If you are innocent before you're arrested and there's an investigation going on, take a polygraph. Pass the polygraph. There's a lot of police departments that say, you pass the polygraph, we don't have a strong case, you're not going to be charged. And guess what? If you fail the polygraph, they can't use it against you anyway. But how cool would it be is if you're charged with a crime and you take a polygraph and you pass and you tell the media that you passed the polygraph. Come on. If you hear somebody pass the polygraph, do you not think they're innocent? I do. I hear somebody pass the polygraph, I think, he passed the polygraph. And what do you think if somebody failed a polygraph? You think they're guilty. If you're innocent, take one. It can only help you. Defendant testifying. I've already explained that. A lot of lawyers will say, well, you don't have to testify. If you don't get your case dismissed on what's called a directed verdict, take the stand and defend yourself. And by the way, it doesn't mean your testimony is not going to be perfect. Any of us defense attorneys can get some points, even from an innocent person. But the main thrust of your testimony and truth will shine through. And besides that, if you're charged with a serious crime that you're innocent, can you imagine serving jail time and you did not stand up and defend yourself? Beyond a reasonable doubt, I've already explained that. I've already explained the jury process. Appeals, very important to just state, you have the right to appeal once to a court of appeals in Ohio and Kentucky, and you can appeal to the Supreme Court, but they don't have to necessarily take your case. There's mandatory appeals in capital murder cases and things like that. In addition to that, this is very important, that your appeal, the judge has discretion to let you out on bond pending the appeal. Sometimes they do, sometimes they don't. In other words, you can be sitting in jail while your appeal's going. You could win your appeal and you've already served all that time. But that's something to consider. Double jeopardy, I've already explained it. Miranda rights, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to be represented by counsel. If you don't have money to afford counsel, a lawyer will be appointed for you, yada, yada, yada. I think I did that actually pretty good. Bottom line is, if they're going to do a custodial interrogation, that's when they Miranda. Reasonable suspicion. You know what? The bottom line is to pull you over, they just got to have reasonable suspicion. Just like probable cause. Well, he looked funny. I mean, it's broad. Checkpoints. They are allowed to do these DUI checkpoints if they announce them. They can't ambush you. But they can go on Friday night and they can announce, we are going to do a checkpoint on Dixie Highway in Erlanger. We're going to do a checkpoint on Montgomery Road in Hamilton County between these hours. If they announce it, they're allowed to do those checkpoints. Statements against interest. Bottom line is, you don't want to make statements against your interest. Despite my advocacy for innocent people, I cannot tell you enough that if you're guilty, and I'm not going to judge you for being guilty, except I'm going to go ahead and tell you right now, there's some cases I will not take. I will not take people who are guilty, I think, of rape, and I will not take a pedophile case. I just can't do it. I can't do it. Let me tell you something. If you are guilty, keep your mouth shut. Guess what? If you're talking on the phone at the jail, they're taping every word of it. One of the funniest stories is the guy over in Hamilton County that chopped up his wife and put her in a garbage can. Somebody's talking to him about what lawyer he should hire, and somebody suggested that he hires me, and he says, no, I don't want to hire him. His dad is Joe Deters, the prosecutor. Of course, Joe's a distant cousin. He's not my dad. But that was a funny one. But the bottom line is keep your mouth shut to everybody. Don't tell the person in prison anything you did. Don't tell anybody but your lawyer, which is protected, that you're guilty. Okay? Keep your mouth shut. Did I make my point? Custodial interrogation, I've already explained that. Confessions, I'll tell you right now, you make a confession after a full Miranda and you don't ask for counsel, it's going to be tough to throw out. You hear about these battles in the news all the time. He didn't know what he was doing. You know why he didn't know what he was doing? Well, he got a lawyer after he confessed, and that's why he didn't know what he was doing. Waiver of rights. You can waive your Miranda rights. Prosecutor immunity. Pet peeve of mine. I make no bones about it. There's a prosecutor in the tri-state that I know ruined Nicole Howell's life because he ordered her to be arrested despite a police officer giving her the opportunity to take a polygraph and not be prosecuted. As soon as he ordered the police to arrest her, her life as a teacher was over. Her career destroyed. Same prosecutor, I'm representing somebody else who was a black man that was arrested, spent 5 months in jail. Guess what? The police, the prosecutor, and everybody knew that the eyewitness said the burglar was white. And my guy is blacker than Chris Rock. The Michael Nifong case down in Duke is an example of severe prosecutorial misconduct. The problem with this is this, and I am right now challenging this immunity in the Sixth Circuit Court of Appeals. They have what's called qualified immunity up until the time the judicial process starts, the arrest. It's called the investigating stage. You have to prove malice, you can still sue a prosecutor. Let me give you an example. If a prosecutor knows somebody's innocent and they hate their guts and they're going to go out to get them, you might have a claim. After the judicial process starts, they have absolute immunity, just like a president does. Investigation for trial, I just explained that. Public opinion, most people think you're guilty, as I said. So there you have it. I want to stress this. As soon as you're charged with a crime, if you're innocent, keep your mouth shut. Get a lawyer hired as soon as possible. If you're innocent, sing it to the mountaintops that you're innocent. If you're innocent, I tell my clients to cooperate with law enforcement. The bottom line is you need a lawyer. If you are charged with a serious crime in Kentucky or Ohio, and I can get special permission to go to other states, which I do. I'm also licensed in Florida. Call me. Eric at ericdeters.com is my email address. My cell phone, which is going to be on the bottom of the screen, 859-250-2527. If you get charged with a crime, I know you are anxious. Text me. Text me.